On Labor Day weekend, as most families prepared for barbecues and travel, a dramatic and unexpected operation was quietly underway at a Texas airport. Nearly 700 unaccompanied Guatemalan children, some as young as 6, were set to be flown out of the U.S. in a massive, coordinated effort that few outside government circles knew about. Charter buses lined up on the runway, children filed onto planes with nervous glances, and far away in Guatemala, families waited by their phones, desperate for news and hoping for reunions that felt both close and impossibly far. But as the engines warmed and the final checks were made, a different kind of race began. Lawyers and advocates, alerted at the last minute, scrambled to halt the flights, arguing that the children's rights were being ignored and due process was being denied. To them, the government's plan looked less like a humanitarian gesture and more like a rushed, unlawful removal, carried out in the shadows of a holiday weekend. The fate of these children now hung in the balance, caught between a powerful government program and a last-minute legal challenge that could change everything for them. An emergency court hearing was called in the early hours, thrusting the government's actions into the national spotlight and forcing a public reckoning. The events of that morning would spark urgent questions about justice, due process, and the nation's responsibility to protect vulnerable children at its borders, especially when decisions are made in haste. The quiet holiday was shattered by a legal showdown that would echo far beyond the courthouse steps. The outcome of this emergency hearing would determine whether these children would be sent away without a chance to speak, or given the opportunity to plead their case and seek safety. For these children, the stakes could not have been higher, and the nation watched as their future hung in the balance. The Trump administration referred to the flights as repatriations, not deportations, a pilot program for family reunification, coordinated closely with the Guatemalan government. Officials described it as a new approach, designed to return children to their home country in a more orderly and compassionate way, rather than simply expelling them. U.S. and Guatemalan officials insisted this was a humane solution, emphasizing that children were being returned to parents or legal guardians, and that the process was meant to prioritize family unity and the well-being of the minors involved. Guatemala's government echoed these sentiments, calling the program both a moral and legal duty. They stressed their responsibility to protect their young citizens and to ensure their safe return, presenting the effort as a matter of national pride and humanitarian concern. But immigrant advocates saw something very different, a mass deportation in disguise. They argued that the government was sidestepping critical legal protections for unaccompanied minors, and that the process lacked transparency and oversight. Under U.S. law, these children are entitled to due process and a meaningful chance to seek asylum. Many had fled violence or persecution, and advocates warned that sending them back without hearings violated their rights. Advocates feared the government was ignoring individual circumstances. Some children had no safe family to return to, and others faced threats or abandonment in their home country. The lead plaintiff, a 10-year-old orphan, became the face of these concerns, symbolizing the vulnerability of children caught in the system and the risks of a one-size-fits-all approach. For advocates, the program risked sending vulnerable children back to danger, without proper review or consideration of their unique stories and needs. The debate was about more than policy. It was about the safety, dignity, and fundamental rights of hundreds of children, each with their own hopes and fears. The nation watched as the legal and moral stakes came into sharp focus, and the fate of these children became a test of the country's values and conscience. In the early hours of the morning, advocacy groups, led by the National Immigration Law Center and joined by several other organizations, filed an emergency lawsuit in federal court, seeking an immediate halt to the controversial flights that were scheduled to deport unaccompanied children. The suit accused the administration of violating federal and international laws designed to protect vulnerable, unaccompanied minors, specifically naming top government officials as defendants responsible for the policy. At its core, the lawsuit argued that the government was bypassing the legal process that gives children a fair chance to seek asylum, safety, and protection from harm. The lead plaintiff, a 10-year-old girl whose mother had died and who faced an uncertain future, became a symbol of the risks and consequences of hasty removal. Without a proper hearing, her fate, and that of hundreds of other children, would be decided behind closed doors, without the oversight or due process that the law requires. The lawsuit demanded an immediate pause to the removals, arguing passionately that every child deserved an individual review and a fair opportunity to present their case before being sent back. With the courthouse steps crowded by media and advocates, the legal battle for these children's futures was officially underway. The emergency lawsuit triggered swift action. Judge Sparkle Suknanen convened a hearing, questioning the government's timing, removing children in the dead of night on a holiday weekend. She issued a temporary restraining order, grounding the planes and halting the operation. The judge's order wasn't a final verdict, but a pause to ensure children's rights weren't trampled in haste. The judiciary stepped in as a check on executive power, ensuring the law, not expediency, would decide the children's fate. The immediate crisis was averted, but the legal fight had just begun. The emergency stop left nearly 700 children in limbo, their futures uncertain. At stake, the government's authority to enforce immigration law versus the legal protections owed to unaccompanied minors. The case forces a reckoning with the nation's responsibility to children at its borders. Advocates argue that a one-size-fits-all approach ignores the trauma and danger many children face. The courts must now decide if the government's program is lawful or an illegal shortcut. The outcome will set a precedent for how America treats vulnerable children seeking safety. The nation's commitment to law and humanity is on trial, and the world is watching.